So let's talk about dealings with witnesses. So here I'm talking about the dealings that you might have as a lawyer running a trial or advising in relation to some sort of litigious matter with the witnesses or potential witnesses that you might want to call in that matter. So there's some summaries of the key issues on the slide, but let's actually walk our way through them. So a lawyer must not confer with or condone another lawyer conferring with more than one lay witness at the one time in relation to any issue that the lawyer believes might be contentious at a hearing or could be affected by or might in turn affect evidence that any of those witnesses might give. So in other words, you can't bring your witnesses together to get their stories straight. Professional rules effectively prohibit a lawyer from conferring with any witnesses, including a party or a client, that they've called on any matter related to the proceedings while that witness remains under cross-examination. This actually continues during adjournments of the hearing, but it doesn't apply if the cross-examiner has given prior consent, because in so doing, he or she can exercise control over protecting the integrity of the evidence. So the prohibition or the proscription extends to conferring with multiple clients in a matter, though the rule does allow, of course, for the lawyers to confer with more than one client regarding matters that require the clients to agree with each other. For example, giving undertakings to the court or making admissions or concessions of fact or amending pleadings or compromises, that kind of procedural stuff. Under no circumstances, none at all, may a lawyer advise or suggest to a witness that false evidence be given, or nor should they suborn a witness. So suborn is really just fancy language for bribery. So suborning a witness is bribing or otherwise inducing someone to commit an unlawful act, which might include perjury. Sorry, I'm just changing my slides there unmeaningfully. So let me give you a case example. Kennedy and the Council of Incorporated Law Institute of New South Wales, in that case, a solicitor who acted for a plaintiff following the death of her husband as a result of a fall from a train, tried to persuade a witness for the defendant to give an account of the accident in terms that were contrary to an earlier statement that the witness had made and would have been more favourable for the plaintiff that he acted for. This conduct, which interfered with the due administration of justice, was held to justify the solicitor ultimately being struck off. A lawyer's role in protecting the integrity of evidence precludes suggesting to any prospective witness, including the party or the lawyer's client, that the content of evidence what the content of the evidence that the witness should give should be. We can't lead the witness not only in evidence but in the preparation stage. This duty includes an obligation not to suggest answers to questions that might be asked or assist with the wording or the expression of certain answers. The kind of jury training and, jury is the wrong word, their witness training that you see in American movies is just not allowed under the rules that we have here in Australian jurisdictions. This jury includes an obligation not to suggest that somebody might be forgetful, for example, or advising a client or a witness of the consequence of giving certain evidence with a view to encouraging that person to illegitimately avoid answering questions because they want to avoid those consequences. So how do you communicate then with witnesses? No lawyer engaged in a proceeding, criminal or civil, has the sole right to call or discuss a case with a witness. In other words, there's no property in a witness because the court has the right to every person's evidence. So as a general rule, whether or not the opposing party is represented, a lawyer can confer with witnesses who are willing to see them, whether or not they've been subpoenaed to be called by an opponent or not. What about talking to the media? It's going to be important if you're talking to the media to balance three interests that kind of sit together. The public right to know about litigation, so the general rules in favour of open justice. Secondly, the interests of the parties, so privacy, reputation, fairness, and the interests of justice itself, so the extent to which information in the media could affect the jury. And let's face it, we've seen that quite a lot in recent times with the teacher's pet case that has only fairly recently been concluded. So have a look at the barristers' rules, 76 and 77. Barristers can make comment for genuine educational or academic purposes, or they can also answer unsolicited questions from journalists about basic elements of a case, what the client's intentions might be, and even release court documents in certain circumstances. Del Pont basically seems to be telling practitioners to beware of unanticipated consequences, though. It's kind of interesting to think through, and a really good question to think about the balance here. Do you think the rules are striking the right balance? Do you think the interest of justice, the interests of clients are well protected in these circumstances? So you need to remember that according to the Australian Solicitors Conduct Rules, lawyers can disclose confidential client information in certain circumstances. So in particular, Rule 9.2.4 provides that a solicitor can disclose information for the sole purpose of avoiding the probable commission of a serious criminal offence. Or 9.2.5, solicitors can disclose information for the purpose of preventing imminent serious physical harm, whether that's to the client or to some other purpose. The inclusion of these rules highlight the tension that can exist between a lawyer's duty to disclose and the lawyer's duty to retain confidentiality, the lawyer's duty to fully inform a court, and the lawyer's duty to keep a client's secrets. The Solicitors' Conduct Rules bring clarity in the sense that they relate to lawyers' discretion to disclose future activities that might cause harm or be considered serious criminal offences. At a general level, the duty to the law always trumps the duty to retain confidentiality, and disclosure is considered vital, particularly in ex parte applications, already don't remember if I mentioned when we were talking about ex parte applications previously, whether I mentioned the particular rules 19.4 and 19.5. Lawyers let's think about what lawyers how they might be prevented from acting. So they can be prevented by way of injunction from using information to benefit their client that comes to them via a person who is subject to a contractual or equitable obligation of confidentiality in respect to that information. Lawyers should accordingly take care in obtaining information from potential witnesses that is or might be covered by contractual or equitable confidentiality obligations. Okay, in the next video, I'm going to talk about the duties of integrity and professionalism, and specifically how they inform our duties to the court.